You're on time, well, for the most part. So I hope everyone's doing well. So the good news, the bad news, and the good news. So the good news is this is our last topic on future interests. We are done with the topic gap for today. The bad news is that this is the hardest unit on the exam. But here's the good news. So we're doing today rules and perpetuity. And for those of you who studied and read the syllabus closely, you'll see that I am not testing this in the exam. Okay? That doesn't mean you don't pay attention. You'll need to know this for the bar exam. But let me explain why. The rule against perpetuities makes the most simple question insanely complicated. And were I to put this on the exam, every single future interest question would devolve into a rule against perpetuities question, whether I wanted to or not. Because every single future interest you have to evaluate, you need to assess RAP. Most of the time, it's not going to be an issue. And if I want to make an issue, it's going to be very obvious it's an issue. So we'll teach you today, you'll need to know for much later in life. But on the exam, the answer will not be that this interest is struck under the rule against perpetuities. If that's what you write, you're wrong. Every year, one or two students who doesn't pay attention or skips this class does an entire rule against perpetuities analysis, and they get no credit because it's wrong. So I get that out there, but it's also a decently tested subject that you'll need to know later. But the bar exam questions will be much more concrete, not the sort of open-ended questions I have, so you'll know it. All right, so any questions before we get started? Yes?
Yesterday, you were talking about...
What, Tuesday, you mean?
I'm sorry, yeah.
I wasn't here yesterday, but if you were here yesterday, that's awesome.
I was.
If you're talking about property on Wednesday, I'm happy.
There you go. We were talking about examples 16 and 17, and
yeah,
how those weren't automatic. Even though, like, for example, a fee simple determinable would be automatic reversion, back to the grantor. But in this case, since it's going to a third party, in this case, it was from the Hartford School Board to town library.
Well, let me just bring up. Can I put it on the screen? What page number is that on? I want to make sure everyone knows what you're talking about. It's a good. Yeah, if anyone has a page, I remember we did a lot on this last class. I think it's. Thank you. Okay, let me just bring up to it so I can bring up for everyone else to see. Okay, so we have 290. Okay, here we go. Everyone see it? Okay. Okay, so I'm sorry. Please continue your question.
Just you said that wouldn't be an automatic transfer of land as opposed to when it was a fee simple determinable. I guess I don't know why.
Which one would not be automatic? 16 or 17?
I think you said 17.
Okay. 1 second. Let me remember what I said. So 17 says, O conveys to Hartford School Board so long as the promises are used for school purposes, then to town library. Okay, so the school board has a fee simple determinable followed by an executory interest. Okay. So after the fee simple determinable, right? After the fee simple determinable, there's no obligation to take any steps if it's a possibly reverter. Okay. A fee simple determinal is usually followed by possibly reverter in the grantor, right? And there's no requirement to take any steps. Here, and this I think I said you just have to memorize, under the rules of number 17, steps need to be taken for the executory interest to become finalized, right? So here it's actually deemed as if it were not a possible reverter. I realize that's not a very good answer, right? Which is why I probably frustrated you last time. Let's do 16 first. I'll contrast with 17, okay? So 16 says, O conveys to the school board, but if the premises are not used for school purpose in the next 20 years, then to the library. So we say that the school board is a fee simple subject to executory interest, okay? And that will be automatically divested, okay? The reason why is we start off with a fee simple subject to the executory interest, okay? And after the fee simple subject to executory interest is automatic divestment. This one is a fee simple determinable. But because it's not followed by a possibly reverter, it's not automatic. Say it again. Word followed by a possibly reverter, it's automatic. Because it's not followed by that, it does not become automatically. This is not a particularly important point. It's not something that makes a lot of logical sense. But if you look at how it's framed here, you start off with the fee simple subject to executory interest. And this, when you start with the fee simple subject to a fee simple determinable, there are different rules what follows it. There's not a particularly good explanation of why.
So it's just kind of conclusory. There's no real logic.
I think I said last time, just memorize it.
Okay.
Then my answer is the same as you got to memorize it.
Okay.
Yeah, it's not. There's not a.
Because it looks exactly the same.
It's awfully close, right? It's awfully close. The only reason why this one's slightly different is the fee simple determinable followed by the possible reverter is automatic, but because it's executory interest, different rules apply. Just memorize it. Yeah, I mean, there's some stuff. I think I say this at various points. There's some stuff that I can explain to you a very good reason why, and there are other things that I'm going to say memorize it. So if you see a fee simple determinable followed by an executory interest, it's not automatic.
Is there any practical difference, I guess, in your mind?
I mean, it would depend if the person decided to not take legal action. So imagine it like this, right? Let's say the town library never bothered taking steps to re-enter because they thought they had it in fee simple already, right? And they sold that interest to someone else. Because he never took the steps, they never had fee simple. And under the common law, you can't transfer those sorts of future interests. So that actually would make a difference whether they took those steps or not.
So they would have to take legal action in that.
That's what it means. Yeah. That's about the only place I can imagine would make a difference. But this one, I think I said this in the last class, just memorize it. And you'll be okay. But I appreciate the fact that on Wednesday you were talking about the future interest. It makes me very, very pleased. Okay. Any other questions? Last class, again, last class and today's class are probably the trickiest ones of the semester. And there are a few bits that you're simply going to have to memorize. There is a logical reason, but it's so obtuse, it's barely logical. It's conclusory, maybe to use your word. Okay. You're welcome. My pleasure. Anyone else? Questions? All right. Let's do a little mini review of the different types of interests we've discussed. And this will lead us into the rule against perpetuities. So we've divided up our interests into two different types of groups. We have interest where the future interest is in the transferor as a third party. I'm sorry, the grantor. And you have your future interest in the transferee. That's the third party. Okay. You'll notice we don't distinguish them based on who has a present interest. We divide them up based on who has the future interest. So in many respects in this class, you have to work backwards. Okay. So we say the life estate is paired with reversion. The fee simple determinable is paired with a possibly reverter. And the fee simple, subject to condition subsequent, is paired with a right of entry. Nothing new there. In each of these cases, the present interest is with someone, and then the future interest is back to the grantor or the transferor. These are the easier ones. That's why we did these first. The next batch get more complicated. Okay? The next batch is where you have a remainder or you have an executory interest. We've discussed there's two different kinds of remainders, the vested remainder and there's the contingent remainder. Right? The vested remainders, we know when there's a person who's actually ascertained and it's not subject to a condition precedent. Otherwise, the remainder is contingent. And we've also discussed a subclass of the vested remainder. That is the vested remainder that's subject to open. These are the cases where it's a class of children, for example, and there may be new brothers and sisters born to it. Among the executory interests, we divide those as well. We have the springing executory interest and the shifting executory interest. To understand which is which, we ask who's getting divested, who's getting cut short. If the grantor is getting cut short, it's springing. If a third party is getting cut short, it's a shifting executory interest. Okay, nothing new here. Any questions on that much? Okay, we're okay with that. So what we're doing new today is how the common law attempted to deal with these future interests in the third parties. Okay. The common law did not like uncertainty. Judges did not like for things to be up in the air. The judges wanted things to be very clear and very understood that when person X dies, it goes to someone else. When person Y dies, it goes to someone else. They did not want to have contingent remainders where they were determining, okay, was this condition precedent met? Okay, was this person ascertained or not? Was he alive at that point? I mean, if you think about it, there were no birth records the same way we have today, right? There were no clear government records of who was alive, who was born. These were very vague things of when people were born, right? Maybe there were baptism records. Those aren't always very accurate. So there was a lot of uncertainty about trying to ascertain who's alive, when they're alive, who was born first. These are not known facts. So over the years, the courts tried to go around getting rid of this uncertainty. On the flip side, though, and the book mentions this, and I'll just, for your 2-minute hate, if I can, with my respect to George Orwell, a lot of lawyers during this time tried to evade these common law rules. The book uses this phrase, the dead hand of the past, and that's a very good imagery. Very wealthy landlords tried their best to keep property in their bloodlines. And then one method of doing this was the fee tail. We discussed briefly that you leave land only to the blood of your heirs, the blood of your body. But short of the fee tail, it was very often the case that families would merge, right? Families would merge. And you wanted families to merge for property and power. So you may say, I will give my son Blackacre if he marries the daughter from this wealthy family, right? And if it doesn't go him, it goes to my other son. Well, what does that mean? When the father dies, you have a judge saying, okay, did these guys get married? What's going on? Maybe they got divorced? Is there annulment? There's a lot of uncertainty. So the common law developed 4 rules that were designed to eliminate this uncertainty. The 4th rule is the one we studied today that's still in effect, the rule against perpetuities. The first 3 rules have been abolished in virtually every state, Texas for certain, but they've been virtually abolished. And they don't exist anymore unless you're doing old instruments, but unfortunately, you still have to learn them. So I want to walk through these one at a time. And even though these rules have been abolished, if you understand them, you will have a better grasp of the RAP, the rule against perpetuities. So we start with a rule called the destructibility of contingent remainders. Okay? This one is the easiest to understand. The destructibility of contingent remainders. And as I'll do with probably everything in this class, is instead of just giving you a word to describe it, I want to give you an example. This class, more than any other, is the hardest to grasp by words. And I think that examples do the best. So page 304, on page example 25 at the bottom, I just flip all the way up because I'm doing example 17. Okay. So where did I finish off last time? Thank you. So Amala, explain to me, what does it mean to destroy contingent remainders, right? Why would courts do this? Like, what was the thinking behind this destructibility of contingent remainders?
if you, well, from what I got was that if you destroyed the contingent remainder, that condition, it would go back to the best remainder of it.
Mm-hmm.
Because you're terminating that preceding test.
Okay. So the thinking here was, again, judges do not like uncertainty. So Amala, read example 25. Just read it, please. Thank you.
O conveys black equals to A for life, then to B and for A if B reaches 21.
Okay, stop right there. So you can imagine, right? Let's just use family members, right? O is the father, A is the oldest son, and then B is the the second son. It says O conveys black hair to A for life, then to B and her heirs if B reaches 21. So Amala, what is going on here? What is O trying to accomplish here?
It starts with a life estate and then it goes into
Yeah. Okay. Good. Well, what kind of future interest follows a life estate?
vested.
Well, ask yourself two questions.
Yeah.
Is there a condition precedent? Is there a condition precedent for B?
Yes.
There is a condition precedent. What's a condition precedent?
If B reaches 21.
Good.
It's a contingent.
Yes, ma'am. So here we have a life estate followed by contingent remainder. Good. But you see what happens here, right? What happens if B dies before A, right? And B never makes it 21, Amala. What happens to Blackacre?
B's remainder is destroyed.
No, but what happens if we get to the stage where, in fact, B dies before A? Don't say reverse, because O is reversion, right? So we have here, right? A is a life estate, B has a contingent remainder, and Amala is correct, O is reversion. So what the rule of the destructibility of contingent remainders rule said is, let's just cut to the chase, right? Let's cut B out of this altogether. Let's just give O reversion. So if you imagine, it strikes it out, right? Whoops, scroll too far. Imagine if the entire last clause was just cut out. Imagine if it just said from O to A for life. If it just said from O to A for life, then A is life estate, O is reversion. What this rule accomplished was just cutting out the uncertainty. Now, maybe B would live to be 21, right? Maybe B would live a long, healthy life, in which case he would have gotten it. Fee simple. However, the law said we don't want to wait to see how old B is when A dies, right? What if B is off in a crusade somewhere and we have no idea where he is? We have no idea if he's alive or not. He went to war to fight. Let's just cut to the chase, strike it out, give A a life estate, O reversion. Everyone get that? You want to read number 26, please, Ryan? I think it's on the next page. It's okay. Oh, your colleagues are so nice and gentle. They hand you their books all at once.
Number 26.
Example 26, yeah.
The open base, white acre, the A for life, then the B in their air, the B survives A.
Okay, so stop reading right there. So tell me, what kind of interest does A have?
Life estate.
Okay. What kind of interest does B have? What's his future interest?
That is a,
Ask us two questions.
it's a piece of subject
No, what?
condition.
No.
I mean,
What follows a life estate? What future interest follows a life estate in every single case we've done so far?
remainder.
Yes. Don't forget that, right? I know you're going to do this. You see this if. You see right this if word, right? You think, oh, that's the condition subsequent. No. If it's a future interest in a third party following a life estate, it's a remainder. What kind of remainder is it? I'm sorry? Ask up two questions.
Ascertain.
Is B ascertained? Do we know who B is? Why don't you know? Is B named?
Okay, so he's ascertained.
Right. If the person is named, that means he's ascertained. We know who he is. It's not some sort of unborn person. Okay. So what's the second question we ask ourselves?
If it's subject to a condition precedent.
Is there a condition precedent here?
Yes.
What's the condition precedent?
B survives A.
Good. So what kind of remainder is it then? Yes, sir. Okay. So under the rule of the destructibility of contingent remainders rule, what happens to this? What happens to this grant? What do we do to the contingent remainder? So then what does it look like? And who has a future interest? What do we call O's interest? Yes, sir. Everyone see that? You just strike it out. So A is life estate and O is reversion. We just get rid of B's contingent remainder. Okay. Everyone with me so far? Oh yeah.
It says that it terminates it if it doesn't like vest at or before.
Mhm.
Wouldn't it be vesting at the death of A?
Okay.
Would it be okay? Like, why is it being terminated? It would be vesting at the right time if she survives.
No, I'm saying if B dies early,
Oh, okay.
right? Okay. So his question's a fair one, right? What happens if in fact B is alive, right, at the time of A's death?
Yeah.
Then, right, then it's not going to be struck. Okay. All right. Let's do the one sec. Hold on. Wait. Right. Yeah. Yeah. Just go.
So we only strike it when that condition doesn't.
Yeah. Yeah. You strike it. Yeah. Okay. The purpose of this and the way they describe in the book, it's destroyed if it does not vest at or before the termination of preceding estate. So basically, just strike it out. So in the example I mentioned before, B's dying early, right? And if B dies early, then you just strike it out. Make sense? Yeah. Go with me. Yeah.
But if you got early, would there not just be a reversion back anyways?
Right, which is why this rule is somewhat redundant. Right? This is why, in part, why it's been the rule has been eliminated. But it was meant to deter people from drafting these instruments that had these contingent remainders. That makes sense.
Which says, I guess, but they wanted to have-
So before this rule was created, you couldn't even draft a contingent remainder, period. So this was kind of like a follow-up to it. Okay. Again, there's certain aspects of this class that I will say very frankly, there are not particularly good reasons why they're there, and that's why the rules have been abolished. Okay? Everyone with me? Okay, let's try the next one. The what's the next one called? The rule in Shelley's case. Okay? And the purpose of the rule in Shelley's case, which has these beautiful 4 lines, was to prevent a situation where the present interest was in a person and the future interest was in that person's heirs. So look at example number 27. It says, O conveys Blackacre to A for life, then to A's heirs. Russo, why is that strange, the way they phrase that? Why is that odd, the way that's phrased? What's weird about number 27? Yes, right? It's basically the exact same as a fee simple. Exactly right, Russo. It's to A for life and to A's heirs. I mean, practically speaking, if I said to A and his heirs, A would have it for his life, and then we'll go to A's heirs. But what's the difference, though, here? What's the difference, Russo? There's a big difference between this, giving A a fee simple, giving A the life estate. What can A not do during his life? Yeah. So the biggest difference is A can only convey life estate. And you know, no one is going to buy a life estate from A because it ends at his natural life. So the reason why people did this, and again, go back to feudalism times. You have some guy that doesn't trust his son. He's like, well, you know what, son? I'm going to give this to you for your life, and then my heirs will get it. Or remember we did the case where the old man married the younger woman, and he let her out of the life estate, and the rest went to his grandkids? It's the same type of thing. So what the rule in Shelley's case basically merges it, right? So in example number 27, A's life estate merges with the remainder. So what the rule in Shelley's case does, it says A has a fee simple. It basically treats it, as Urusa correctly noted, as if it was one estate. So what the rule in Shelley's case again does is it strikes out the life estate and it merges it together such that A has a fee simple. Again, the reason behind this isn't particularly as important as what actually ends up happening. We're trying to get rid of these contingent remainders. What actually happens here, if you think about it, A is a life estate, and A's heirs have contingent remainder. Why is it contingent? Because heirs are not ascertained until death. So it's another way of getting rid of a contingent remainder. Everyone with me so far? Again, another rule that's been demolished. I think I actually have the. I think there's actually a Texas statute abolishing these. I think I put it up here. Oh, this is the. Yeah, Texas abolished the rule in Shelley's case. If you want to click the link, it's gone. So you don't have to worry about it. But it was existing at one point. Okay. Any questions on Shelley's case? It was named after a case called Shelley's case. It's not particularly important. All right, let's go to number 28. Example number 28 concerns something called the Doctrine of Worthier Title. Pierce, want to read example 28, please?
O conveys Blackacre to A for life, then to O's heirs.
Okay. O conveys Blackacre to A for life, then to O's heirs. So Pierce, why would O do this, right? What's O trying to accomplish here?
He doesn't want to sell it.
Yeah.
He wants it basically to come back to himself.
He wants to come back to himself. So why wouldn't he just leave it straight up to his heirs?
Maybe he wanted A to have it for a little bit. He liked him, but he didn't want to give him the option to sell it.
Yeah, that's probably it. Again, this is the idea that you're trying to give land to someone only for their life, and then it comes right back to you. Comes right back to you. So the Doctrine of Worthier Title says, okay, is where there's like a life estate to a person, and the future interest of the grantor's heirs, they just strike out the future interest. And what ends up happening is that O is reversion. It's not in O's heirs. O is reversion straight up. Again, the common law does not like contingent remainders. The heirs of O will not be known until O dies. They don't like leaving land just to random whoever these people are. So the court would just strike it out and say, you know what? To A for life, period. O is reversion. You notice it's basically the exact same answer in each of the three examples I gave you. Was it 20, 26, 27, 28? You just strike it out and it says to A for life and the reversion to the grantor. If you're sensing a pattern, that's what happens. They strike out the contingent remainder after the life estate and give it back to the grantor. So if you ever encountered with one of these questions, right, and you're not sure, and if you have to guess that the grantor has reversion. The odds are you're probably going to be correct. I'm not telling you this is right in every single case, but in a significant number of these issues where you're not sure, just say the grantor's reversion. Yeah, Jill?
Yeah, my question was, were they trying to avoid the estate going, property going back to the grantor? Was the grantor's intent preventing it from going back to him in case creditors were trying to get it, which is go directly to the heirs?
I don't think it was so much about that. I think they didn't want to have to calculate who heirs were. And they also wanted land to be alienable, right? Because you could actually convey a reversion inter vivos, right? You could actually sell your reversion during life because it was certain to come back to you. your heirs could not sell a contingent remainder that wasn't something that could be sold during life. They also not only wanted to make things certain, they wanted to make land alienable. And these examples are all ways, oh, right, but imagine this went on over, 20 generations. And, there's 75 different heirs. And you're trying to calculate, okay, this heir and that heir and that heir. It becomes very tricky to figure out. They're cousins and, aunts and uncles and all these other people. So this was meant to simplify things. And finding O, or whoever, O was, is much easier than finding out all the heirs of O. Make sense?
What if O is dead?
Well, under the doctrine of primogeniture, it would be O's firstborn son.
Okay.
And under primogeniture, that person's firstborn son. So it's a lot easier to find the line of O than all of O's heirs.
Okay.
Because we discussed the heir is broad, because it includes sons, daughters, brothers, sisters, cousins, everyone. Whereas under primogeniture, I mean, it's a difficult doctrine for us to accept in 2016, but it was meant to make it one male born. And if there were no male borns, then they start looking at second born males and all these rules. But it was meant to keep things simple. Okay. So any question on the doctrine of worthier title? Again, and again, if you don't believe me, I have the link here. Texas abolished these some years ago. The wise people in Austin who, oh, that link is broken. The link used to work. But take my word for it, it's abolished. It's section, I have in my notes. Section, Texas Property Code, section 5.042. Look it up, it's there, I promise. Okay. All right, so any questions then on the first three doctrines we discussed? Okay, the fourth one is the one that gives law students shivers in the night. For whatever reason, the rule against perpetuities is like the topic that people remember the most as being evil. I don't know why, but people hate it the most. What you have to understand about the rule against perpetuities is that it was designed to prevent someone from leaving property to a person who wasn't born yet. Or to say it backwards, it was designed to limit property to only people who are born, or maybe people who you may know will be born soon. It's the same idea that, grandma may want to leave property to her grandson who's alive, but won't know much about her great-grandson who hasn't been born yet. The goal of the rule against perpetuities is to constrain grants of property to people who are alive now or people who may be alive in a reasonably foreseeable amount of time, which is, in this rule, 21 years. So there's this classic framing by Professor Gray, and I'll write it, but it's not the best, but this is the best one we got. It says, no interest is good unless it must vest, if at all, not later than 21 years after some life and being at the creation of the interest. Okay. No interest is good unless it must vest, if at all, not later than 21 years after some life and being at the creation of the interest. The goal of this policy was to make sure that someone could provide for everyone in their family and one generation after that. In other words, when the person attained the age of majority of 21. So you can provide for all of your living family members and at least the new generation who will be around 21 years after that. That was what the goal is. Now, what happens if you try to give a property to someone beyond that 21-year period? The court would strike it out, right? The same way they would destroy contingent remainders and the worthier title doctrine and the Shelley's case rule. You strike it out. Under the rule against perpetuities, at the moment the document's drafted, if you're trying to leave property to someone too far into the future, too remote, right? The courts will simply strike it out. and invariably reversion is added. That's not always the rule, but it may be. All right. So I want to walk you through the mechanics of applying it. I think the book does a fairly decent job of explaining this. But again, unless you have examples, and we'll probably do about a dozen examples of these today. Unless you have examples, the topic just will not click. Okay. So the first thing, and the book calls this step one, it's hard to even label these steps because they're so amorphous, but I'll use the book's terminology. The first thing you have to ask yourself, right, is the future interest we're talking about subject to wrap? Is the future interest subject to wrap? Okay. The only types of future interests that are subject to wrap are those in the third party, or those in the transferee, right? And there are three types where the future interest is in transferee. And this is how I began class. There's vested remainder, okay? Okay, there's contingent remainder, and executory interest, right? The first one, vested remainder, is not subject to wrap. If it's vested, it's certain to occur, right? The vested remainder is not subject to wrap. The other two, the contingent remainder and the executory interest, are subject to wrap. So when you're looking at a question, right, and this is, again, why I don't test it, because every single question becomes infested by the rule against perpetuities. But in theory, whenever you're looking at any grant, the second you see, oh, wait a minute, there's a contingent remainder. Oh, man, there's an executory interest. You say, okay, I need to start thinking, are these going to be struck out because of the wrap? Wrap is rule against perpetuities, right? Will wrap strike these out? If it's a vested remainder, you're good. There's certain to occur. There's no condition precedent. You're fine. However, okay. Oh, I should note though, the vested remainder subject to open is subject to wrap, because again, which is again why I don't like testing on this. But even if it's a vested remainder, if it's subject to open, it would be subject to the rule against perpetuities. Why? Because it's not completely vested, right? There may be new people coming into the class at some point after 21 years life and being. Okay, that's the easiest of the rules, but everyone get it so far. Everyone with me? We'll do this really slow, okay? The rest of the class will do nothing but examples, and I hope to drill this into your head well enough. Okay. The next step, again, the book calls it step 2, but there's a lot of stuff within step 2, is you have to ask yourself a question. And the framing of this question is odd. Okay. Your goal is to try to strike things down that happen too far in the future. So you have to prove that a contingent interest will vest not later than 21 years after the death of some person that's alive. Let me say it again. Okay? You have to prove, and when I say prove, you need proof, that a contingent interest will vest no later than 21 years after the death of some person who is alive at the creation of the interest. Okay, I'm choose my words very carefully here. So let's go through this one bit at a time. When I say you have to prove something, that means you have to actually do arithmetic. You have to actually say, is it possible that this person will reach the age of 21 within 21 years of the life of a person in being now? Okay. You also need to calculate who is alive at the creation of the interest. This is what's often called the validating life. You need to find someone who's alive. And that's the person you can count 21 years from their life. Okay. I'll give you a funny example that makes this real. But very often, to get around this rule, English lawyers would say, born within 21 years of the life of the King of England. Well, there was always a King of England, right? They would pick someone who's always alive. The courts found a way to strike that one down eventually. But the idea is you have to leave it to someone who's connected to a person alive now. You can't control property too far into the future. Okay? I know that doesn't make any sense right now, but I want to do a bunch of examples. And it will make more sense, I promise. So go to example 29, please. Want to read it for me, please, Jacqueline? Oh, did I skip over this section? Did I do your row?
Yeah, we did our.
Did I do this row? Okay, I'll start with you then. Occasionally I skip rows and it's not deliberate. So Florencio, you read number 29, please?
In trust for A for life, then to A's first child to reach 21.
Okay, well, let's go through this one very, very closely. It's on the bottom of page 309. Okay, so it says, O transfers a sum in trust for A to life, then to A's first child to reach 21. Okay, so before we get to wrap, let's just do what we would usually do, Florencio. We've done this a million times, right? What is A's interest here?
Life estate.
A is life estate. Again, we're talking about money, right? But it doesn't matter what we're talking about. Money, land, same deal. Okay. What is the future interest that follows the life estate?
It's a remainder.
Yes, sir. Now, is A ascertained?
It says first child, so I would say he is named.
Okay. I said, is A ascertained, right?
Yes.
Okay. Is A's first child ascertained?
No.
No, right? We don't know who A's first child is. Maybe A will have no children, right? A could die barren. Okay, so A's not ascertained. Is there a condition precedent?
No. Well, he has to reach 21, so yes.
Okay, so in this case, the person's not yet ascertained, and there's condition precedent. So what kind of remainder do we have here? Okay. So now you say, wait a minute, Blackman said step one. We have a contingent remainder. So we have to start looking at the rule against perpetuities. Okay? The rule applies because we have a contingent remainder. All right? So very good. I'll move on next to Carlos. Sir. So the first thing we have to look at is we have to find what's called a validating life, right? Who is named here? What person is actually in existence here that maybe we could use to measure life? Who do we know about here?
A's name.
Yes, okay, exactly right. A is our validating life, right? He's in the instrument, he's in the document, he's alive. Now, the condition is this, Carlos. A's child must reach 21 years of age within 21 years of A's death. Let me say that again. Carlos, if A has a child, right? Okay. Can A have a child when he's dead?
No.
Okay. A cannot have a child when he's dead. What happens, let's just make A a female, make it easier, right? A is the mother, she has a child. The day her child dies, she dies on the delivery table, right? She dies during childbirth, but the child survives. Will the child reach 21 years of age at some point? Yeah, assuming he doesn't die, but he may reach 21 years. Now, here's the tricky part. Carlos, will the child reach 21 years within 21 years of his mother's death? He would have to. I'm so glad you said it that way. Listen to what he just said. He would have to. It would be impossible for the child not to hit 21 within 21 years of the mother's death, right? It would be impossible. Even if the mother died during delivery and the child was born. You can prove, and that's the key word, you can prove that within 21 years of the mother's death, the child will turn 21. 100%, right? The remainder must vest in this time. Okay. Now the question I know someone will ask me, Sarah, what happens if the child dies before the age of 21? What if he dies when he's 5 or whatever, right? Well, no, you're right, but do we have to strike the interest though? That's the question.
I don't think so because it was valid when it was created.
Yes, the remainder was valid when it was conveyed, right? It may not vest at all, and that's fine, but it can vest in that time, and they would have to vest. In order for the condition to be true, it would have to vest in 21 years. Okay, so this is actually valid. Sarah's right. Owed every reversion if the child dies early, right? No question. But what the rule against perpetuities would actually do, and we'll do example number 30 in a minute, is strike it out and even eliminate the possibility that A could ever get anything, right? Let's look at number 30, and then Carl, read number 30, please, on the next page.
Don't transfer the sum we trust for A for life into A's first child's reach 25.
Okay, so this is very similar to the previous example, except there's one big difference. The big difference is this. In the first one, the child had to reach 21. And in this one, the child has to reach 25. So Carl, how does this one turn out differently?
On A's death, that clause gets struck out because it's
Is it conceivable?
Yeah, it's conceivable that when the day A died, at that point in time, the child wouldn't be 21 years after.
Right.
Or
Okay.
the child wouldn't reach 25, 21 years after.
Okay. Let's focus on our language. Carl is exactly right. I want to focus on our language very carefully. Carl, is this condition certain to vest within 21 years of the life of A? No. The condition is not certain to vest within 21 years of the life of A for the exact reason. Imagine, again, the mother dies on the delivery bed, right? She dies in the hospital. The child is born in the year 2000, right? Child would turn 25 in 2025. That will be 4 years after the 21-year limit. Because the condition is not certain to vest, Carl's exactly right. We strike it out. So all it says then is to A for life, period. We strike out this last part, that's this 25 business, we strike it out. So A's life estate, O is reversion. There's no chance that even if A's child lives to reach 100 years old, right? It won't matter because the condition is struck. Everyone with me so far? Okay.
So O will be bringing this up, like if he wants his property back, and he will bring the call back and saying, "Hey, this is important."
Yes, what would actually exactly right. Someone would bring suits saying we have to strike the contingent remainder because it's void under the rule against perpetuities.
Otherwise, if they didn't bring cause of action, would the transfer value? Like if
it would be whoever. Let me put it this way: if the time for O to act would be before the child reaches 25, right? You would try and bring something early, if I had to guess. Your hand up?
Yeah. So it makes a point to say that A has no children aged 25 or older at the time it's written. But then, and I'm assuming it's the time that it's written that the rule.
Yes, you
important, right?
you measure at the time the conveyance is drafted. Now, let me ask Sarah's question differently. Right? What happens if, in fact, A had a child at the time and the name was Bill? And it said when Bill reaches 25, right? Well, then you would calculate how old is Bill now.
Right.
If he's 0, still won't work. But if he's, actually, if you think about it, if you name someone to vested remainder, well, but still be contingent. So you'd actually have to count how old Bill is at that point. And if Bill is only 0 years old, he won't be able to reach 25 in a 21-year window.
And I'm assuming we don't care if a later has children, because longevity and children for well over 25. We don't care about that because when it was drafted,
Yeah.
there were no, it was impossible.
Because it was a contingent remainder, right? Because the condition precedent is here, it may not be certain to vest in the time, because no matter how many kids you have, they may all die in a horrible train wreck on the same day, in which case she has none. Everyone get examples 29 and 30. Yeah.
So just ask a dumb question.
Today, there are no dumb questions, my friend.
Let's say someone is 20 and it's, I guess you can say it's certain to refer that they will reach 25 within 21 years.
Yes.
Not strike that.
No. Right. If the child was already 20 the time the conveyance was drafted, and it said till the child reaches 25, okay, he has 21 years and he only needs to go 5, right? So that's certain to happen, and that's a contingent remainder that would survive. Okay, everyone with me? Yeah, there are no dumb questions today. This is one of those topics that we're going to do question after question after question, and my sincere hope is that after all these examples, it clicks, and if it doesn't, go back and do the examples again. But this is a tricky topic. All right, you want to read for me, please, Jeremy, number 31?
T divides his property to my grandchildren who reach 21. T leaves 2 children and 3 grandchildren under 21.
Mm-hmm.
Validating life.
Oh, no, stop it. You're reading the answer. Okay. So I appreciate that all of you are not going to read the answer. It's actually very, very helpful because the book puts it right there for you. But I want to try and work it out with you. So it says T leaves property. Devises just means leave in your will. There are some distinctions which I don't particularly care about. If you want, you can read that footnote. But for our purposes, it's the same thing. So T leaves some property to my grandchildren who reach 21. And it says here, at the time of the conveyance, right, at the time that this is happening, T has 2 children and 3 grandchildren under the age of 21. Okay? So here's the question, right? Jeremy, at the time we're talking now, have any of his grandchildren reached 21? Not yet. Okay. Will they reach 21 eventually?
Assuming they don't die yet.
Maybe yes, maybe no. But your question's fine. What if they die? The other question is, are there possibly more grandchildren to be born? How can there be more grandchildren born?
When T's children.
Yeah, I realize it's like family matters, right? You have to actually count it through. T still has living children. And we presume so long as T has living children, they can pop out new grandkids. Okay? They can create new grandchildren. So even though there are only 2 children today, in 80 years, right? What if T's daughter pops out another couple kids? Right? Would those people be potential beneficiaries, Jeremy? With those grandchildren in 80 years, she pops out new kids? Is there any problem with that?
I want to say you start counting 21 years after T dies.
Oh, so that's wrong. I'm glad you said that. Okay. How do we know? And you actually answered it before. You probably didn't realize it, but I asked the question deliberately. How do we know who will have more grandchildren, right? Who's responsible for having more grandchildren? You said it already. So who's our validating life? Who's our measuring life? Yes. Everyone see that? We're not basing this on 21 years after the death of T. We are not basing this on 21 years after the death of T. We're basing this on 21 years after the death of T's children. Because we presume that a person is fertile to the day they die, right? This fertile octogenarian business. So even if, T's child, right, is like 80 years old, we presume she can still pop out more kids, right? And if we say that, right, what happens, I'll go to Cody. Cody, what happens if T's child has a, pops out a grandkid on her 90th birthday. Okay, and then she dies. On her 90th birthday, she gives birth, and then she dies, and she's the last surviving child. Right? Will that gift be valid to that grandchild? 21 years from the death of the last surviving child. Okay, the validating life is the last surviving child, and if that person gives birth on her 90th birthday and then dies in the operating table, that gift is still valid because it'll be 21 years from the life and being of the child. 1, 2, yeah.
So does it have to be bloodline, or does a legal adoption?
I'm sure under the common law, the answer was bloodline, but under today, adopted children are considered, for all intents and purposes, biological children. So I guess it's when the adoption was finalized, I suppose. Yeah.
Does it matter if it's medically impossible for someone to have children?
No, and that's actually the point. It's a legal fiction. We presume that even a 90-year-old sterile woman can give birth, right? We presume everything. And the flip side, I mentioned this in class last week, is the precocious toddler. We presume even if a child is basically 1 year old, that they're capable of reproducing. Which is, it's not as insane as it sounds. I actually found one story, a couple in the books, where there was actually where was it? Yeah. I'm pretty sure this is true, but I'm not sure. But there was actually a girl, and I'll call her a girl, who was 5 years old. I mean, she was raped, obviously, which is not mentioned in the story, but indeed, there's not a consent for 5-year-olds. And she gave birth at 5, and here's a picture of the doctor holding her and the baby in the stroller. Surreal, and if you read this, it says her parents thought she was possessed by evil spirits. Yeah. They were doing a real good job watching her. It is another story which I found that was also surreal. But a man actually adopted his girlfriend in order to cut his children out of the picture. This stuff happens. Because the money was supposed to go to his kids, and now his girlfriend/daughter would get it. You do some crazy stuff in trust law. It's crazy. So, no, because if you married, you would inherit as an heir because the wife doesn't take, the children take under the trust. Yeah, crazy.
Would that not be a sensitive dangerous subject to open? Because what grandchildren turn 21 after?
I'm sorry, say that again?
It says that my grandchildren are 21, so after they pass, and then you have the grandchildren that are some are 21, and then you have others 20.
A vested remainder subject to open is also subject to broken perpetuities. Right? Remember I said at the outset, vested remainders are not, but a vested remainder that's subject to open is subject to round.
So this is subject to open?
Yeah, no, this is subject to open. This is not contingent. Right? Well, at the time, hold on, were they? Yeah, there were some grandchildren at the time, so it would be a vested remainder subject to open. That's right. It would not be contingent remainder. Good call.
So the validating life has to be someone who's named in the things, right?
Not necessarily. So this is where the rap goes off the rails. So the validating life does not need to be named in the instrument. You need to understand the validating life in light of the condition, right? So the condition, all the thing says is T divides property to my grandchildren reach 21. This is why I asked Jeremy a minute ago, how do we know who the grandchildren will be? Well, that's going to be based on the children of T. So that tells you that the validating life is the children of T because they're the ones who spit out the grandkids. Even though the children of T are not mentioned anywhere here, they're still the validating life. And this requires the courts to go and actually, investigate a family tree to determine who's who. That makes sense.
But see, I guess that's why wouldn't the validating life be one of the
You need to determine if the grandchildren are valid. And to do that, you see if there's a life and being plus 21 years. And the life and being to pop out grandkids are the children. That's where the children are the validating life.
So I mean, I understand that obviously if the kids can have kids and then grandchildren coming around.
But kids can always have kids. That's presumption.
Well, I'm saying if they're not, like, I understand why you're saying that that's validating life, but I'm confused why the grandchildren can argue that they're validating life. Like, say that instead of 21.
What happens? Okay, let me ask you a question. There are two grandchildren. There says there are 3 grandchildren here, right? What if tomorrow all 3 of them die before Grandpa? Could any of them be a validating life then? The only way you measure it is if there's still children who are alive. What if at the time, let me ask you this question. What if at the time of T's death, all of his children are dead and all of his grandchildren are dead? Right, there will be reversion, right? But we assess this at the time it's granted, okay? And in order to understand if all the children confess, we have to understand it from the children, not from the grandchildren. To identify the validating life, and I freely can see this is not always entirely clear, you have to understand the condition and who are we measuring from to get to that condition. We have to see if all these grandchildren will be alive 21 years from a life and being. And that life and being has to be their parent. Still confused? Okay, let's do another example. 32. Okay. You want to try it, Jonathan? Read it, please. Just read the first part.
The sum in trust for age for life, and to age children for the life of the survivor of them, and upon the death of the last surviving child of A, to A's grandchildren.
Okay. Was that in the question or no? No. I was like, was that the guy's name? I forgot. Okay. So yeah. You can pray for this one, right? Let's read this one step at a time. Oh, and to make it even more complicated, A is 80 years old, and she has 2 children, B and C. But let's go one step at a time, okay? So T gives a sum to A for life. That's a life estate, okay? Then it says, then to A's children for the life of the survivor of them. Okay? How would we characterize just that clause? We'll go one clause at a time. So we have a life estate, and it says, then to A's children for the life of the survivor of them.
Is that their children? A's children?
A's children. A's children for the life of the survivor of them.
Not remainder. Where am I getting?
How long do A's children have it for? Read it. You're trying to do something else, but look what it says. A for life, then to A's children for the life of the survivor of them. So what's actually happening here? Watch, I guess, yeah.
Is it whichever child that lives with them?
Yeah. So it's basically a joint life estate, right? And they basically get it together for life. And whoever lives the longest gets to keep it. So let's, say brother A and brother C, Joe and Bob, right? They have it as a joint life estate. And if Bob outlives Joe, Joe keeps it for his life. So here, with this rare situation with a life estate, right? Followed by a remainder in life estate, right? The remainder is actually another life estate. You stack them. So the life estate followed by the remainder of the life estate. Okay. Then, we're not out of the woods yet. It says, then upon the death of the last surviving child of A, to A's grandchildren. Okay. So what makes this question very complicated is, how do we know if A will have grandchildren? Okay. How do we know if A will have grandchildren? So, Jessica, how does A have grandchildren? In order for A to have grandchildren, what must happen? Well, certainly, but for A to have a grandchildren, what are the 2 things that must happen first? Think very, family-wise. What happens?
They have to get pregnant.
Yeah. A has a child, right? And then A's child has a child. So 2 things have to happen, right? A is a child, and A's child has a child. Right? So follow me here, Jessica. Ready? This is what he said, Jesus, right? What happens? What happens if after this instrument is drafted, right? B and C die. Okay. Who is the measuring life in this case? Who is the validating life? We just did it a moment ago. Who will be the validating life to determine the grandchildren?
Stealing.
No. To determine whether grandchildren can take, the example we did a minute ago, who is validating life in this question?
I'm getting confused because the grandchildren are born already.
We just did this example 5 minutes ago. I was talking with Cody, and Jeremy. Who is our validating life? Who do we measure from to determine if the grandchildren can take? The children. Okay. The children are the validating life. Everyone see that? The children are the validating life. Because in order to determine whether the grandchildren are taking 21 years from life and being, we have to look to the children. You with me so far? Okay. All right, Jessica, so let's finish it up. Is it possible? Is it possible for A to have more children? Okay. So what happens if we have the validating life, right? B and C. What happens when 50, no, not 50. What's that in 20 years when she's 100? Right? B and C are both dead. And then A pops out a new kid. Right? And then 40 years later, that kid has another child. How far will that grandchild have been born from our measuring life, our validating life?
No, 40 years that would be beyond because the
Yeah.
That A has to be
Yes.
in the validating life. So we have 21 years after.
No, B and C are validating lives.
Yeah, but they died.
They're dead. So once you identify the validating life, very good. Once you identify the validating life, that's it. You're stuck with them, right? Once we say, and Jeremy was right, and Jessica's right, here our validating lives are B and C. Okay? B and C are our validating lives. What happens if then a child is born X? You know, in 30 years, when she's 110, God bless her, right? When she's 110, she gives birth to an X. X is not a validating life. And then what happens if X has a child when she's 40? You now have almost 70 years of elapsed from the death of B and C when a grandchild is born. Because all of those years elapsed from when the grandchild was born, long after the death of the validating lives, it's void. In other words, let me say this very carefully. I wrote it down so I can. Because the grandchild cannot be certain to be born within 21 years of the life of B and C. Let me say that again. The grandchild cannot be certain to be born within 21 years of the life of B and C. Therefore, the future interest is void. You strike out the future interest. And once again, T has reversion. You strike out the contingent remainder, or actually it would be a vested remainder subject to open. You strike it, and it goes back to T. The reason why, let me say it one more time, is because what if A has another child? And that child is another child long after the death of B and C. We go more than 21 years beyond our validating life. That's why it's very important to identify your validating life at the time the instrument is drafted. The validating life is not A. The validating life is B and C. And if you're ever uncertain, right, and we've already done 3 questions like this. If you're ever uncertain who the validating life is, If you're dealing with grandchildren, the valuing life is almost always going to be the parents of the grandchildren. Right? I can only ask this question so many ways. Right? You know, we've done 3 examples, basically the same question over and over again. More often than not, if we're talking about grandkids, I'll give you a second, the valuing life is their parents. Not always, but you can run with that if you're not sure. Yeah, Jonathan?
You say if B and C died.
I'm sorry?
I'm just clarifying. You said if B and C both died,
Yes.
but A had another child, X,
Yes.
and within those 21 years, X had a kid.
Right.
Say X could not be the validating life.
No, because X was not in existence at the time this was drafted. X was not yet born, right? In order to be a validating life, you need to be alive at the time the instrument's drafted. You assess everything when the instrument's drafted. I think your hand was up?
Yeah, it's really silly. but-
Yeah, no, it's not silly. There are no dumb questions today, I promise.
Why are we assuming that B and C will die?
Because we're morbid. We have to prove that it's certain, right? That it's certain to vest. And it's not so much, even if B and C are still alive, right? Even if they're still alive, because A can have a child very far into the future, it may still be 21 years after their death. Okay? We presume that people may die. We go out of our way to try to get every convoluted circumstance where this interest may be voided. Okay? Imagine you're a judge, right? Back in the jolly old England. And you're saying, man, I hate these contingent remainders. I'm going to try to find a way to destroy it. Let me make up this convoluted scenario where her children died, and then she gives birth at the age of 110, you know, to a child, right? It's insane. But the judges went out of their way to make it as complicated as possible and to imagine all these scenarios where it may be voided, and that will invalidate the interest. Which is another reason why I don't test you on this, because you can get really creative and like just destroy my fact pattern and make all these insane hypotheticals, which don't teach, you know, they don't show me if you know what you're talking about. That's why I don't ask about it. But the thought process that Urusa asked about, you're a judge and you're trying to think of every conceivable ground on which you can strike out the contingent remainder. That's what this rule developed as.
If you had one of these people come to you, the T or the A or the B or the C, and they show you this instrument, is this something that you would say this will fail the rule of perpetuities? And is it not too late until A and T and everybody's still alive? Is it okay to change the document?
Yes. But what's interesting though is once this instrument is drafted, right, you would then need all of the possible future interest people to merge and agree. They all, right?
Because once T devises this is the present interest.
Yeah.
In those future interests.
So you need A, and you would need A's children. But again, the problem is A's still alive, and she may have more children. So you can't even represent the interest of an unborn child yet, because A can always pop out more kids. This is why the courts hated these, because once you drafted this, you were screwed.
Okay.
This is why they just struck it out, and they said reversion for T. Get rid of it. So at least it will be around for maybe 1 or 2 generations, but not like, 80 years in the future. The entire goal of this, and I think Sarah and Arusa asked the same question in different ways, was how to make up these convoluted, insane hypotheticals of 110-year-old women, giving birth to kids, dying on the delivery bed, and then their kids give birth in 20. It's insane. But this is how they went about trying to destroy these contingent remainders. Everyone with me so far? Oh, yes, sir.
Draft like a later will.
Once you give away a future interest, you don't have it anymore, right? Once T gave it away, that was it, right? All you had was reversion distance. But once you make these instruments final, that's it. Right? You can't undo this sort of thing. You can't like Control Z. There's no undoing when you give away a piece of property. Okay. All right. Let me try one example that's not in the book, but may help you a little bit. We have time for a couple more. Okay, so let's try this one. I'll write on the board. So let's say O gives Blackacre A and his heirs when the bridge is opened. Okay. O gives Blackacre to A and his heirs when the bridge is open. All right. You want to, Brian, you want to try this one? So what is O's interest here?
O has reversion.
Why would you say it's reversion? I know why you would want to say that, but why would you say that?
Because he has the fee simple.
Well, just OFE simple? Brian, let me ask the question like this. Who owns it until the bridge is opened? Under this grant, property always has to be owned by someone. Who owns it at the moment this property is in existence? At the instant.
O does.
Right, so what do we call O's interest?
Fee simple.
However, could O lose it?
He can when the bridge is
So
open.
what do we call a fee simple that can be cut short?
Fee simple determinable.
No. What do we call it when a fee simple can be cut short?
Executory.
Yes, sir.
Subject to preemption.
Yeah. O has a fee simple subject to executory interest. Oops, that's O, not a parenthesis. O has a fee simple subject to executory interest, right? Because this fee simple can be cut short by some third party. So Brian, what does A have?
A has a contingent.
What do we call the future interest that cuts short an executory interest? What do we call that?
Has a executory.
Did you hear, Sarah? You're right, both of you. Okay, we say A has a springing executory interest, right? Okay. A has a springing executory interest. Why? Because it's divesting the grantor, right? Now, we've done this exact sort of question weeks before. Jaime, I'll leave Brian alone. I bothered him enough. How do we understand this under the rule against perpetuities? What do we do? What's our framework? What's our our step by step? No, that's okay. You can scroll.
Ask if it's feature interest subject to that. Ask if it's the type of feature interest that is subject to wrap.
Okay, is our feature interest here subject to wrap?
Yes.
Why is it subject to wrap?
Executory interest.
Yes, sir. Okay, then what's the next thing we have to determine?
We have to prove that the contingent interest will be vested no later than 21 years after the validating life.
Okay, so who's our validating life here?
That would be. Oh, I figured. There's no life, so it's not subject to anyone dying. So maybe the bridge.
Who is the only person we know of here? We have O and A, right?
Yeah.
What must happen within 21 years of A's death?
The bridge has to be open.
Okay, so A is a validating life, right? Once O gives it, he's out of the picture. He's out of the picture. What effectively has to happen here is that within 21 years of A's life and being, the bridge must be opened. So Jaime, tell me, sir, is there any certainty that the bridge will open within 21 years of A's death?
No.
No certainty at all. None. Bridge may never be finished. Bridge to nowhere, right? So what happens then, Jaime, to this spring executory interest? Destroyed. OSV simple, right? You do is you strike the future interest because it violates wrap, and we say that OSV simple, period. Okay, everyone ever get that example? Yes.
So we don't even wait the 21 years to see if they actually
Doesn't matter.
happen or not.
Right, because it's not certain to vest within 21 years, strike it, right? Okay, let's try another example. Okay, let me type it first. So O grants Whiteacre to A and her heirs if A is elected governor. Okay, O grants Whiteacre to A and her heirs. By the way, these are examples from the examples and explanations book. I don't require that you buy it, but if you want to, it has some pretty good discussions. The E&E series, they're not good for everyone, but the proper book is pretty decent. So these examples are straight from the book. So if you're ever not certain, the library is a copy of your colleagues, so you can go look at these afterwards. These are right from that chapter. All right, so what do you think we got here, Sean? O grants Whiteacre to A and her heirs if A is elected governor.
O would have the present interest again in fee simple subject to the different.
Okay, good. And then what do we call A? Interest.
Spring.
Okay, now let's talk about rule against perpetuities, right? We already said that an executory interest is subject to wrap. Who's our validating life here? A. Okay. Is the condition certain to vest within 21 years of the death of A?
No.
Really? Tell me why. What's our condition here?
He has to be elected governor.
Does A have to be elected governor within 21 years of A's life? Does A have to be elected governor while A is alive?
Yes.
Duh. Right, yes, yeah. Is this condition certain to vest within 21 years of A's death?
If he's elected governor, yes, but no, because he doesn't have to be elected governor.
That's not the question. Can he be elected governor 21 years after he's dead? No. It's impossible, right? It's impossible for someone to be elected governor 21 years after their death. Therefore, the condition is certain to vest. It doesn't have to, and that's a key point, right? He doesn't have to become governor. But if it does vest, it will have to vest within 21 years of A's death. Right? That's what this question is trying to teach you. It doesn't have to happen. There's no guarantee he becomes governor. But if it does, it must happen within that period. Okay. All right. So questions. That's the last example I wanted to get for this. Yeah, Carl. Yeah, exactly. No, the futurist is valid. Yeah, no, it's valid. Yeah, the futurist is valid because it is certain to vest within 21 years. It cannot possibly. Let me write it like this, right? If he becomes governor, he must become governor before A's life plus 21 years. In other words, you can't become zombie governor, right? You have to become elected. So because if it vests, it has to vest in that period. Therefore, the gift is valid. I saw a hand somewhere else. Yeah.
So if it's certain to vest, it has to be.
It doesn't have to vest, but if it does, it must be within that period. That's the tricky part, right? There's no guarantee he'll become governor, right? Who will know if your son will become governor? We don't know. But if he does, it will have to happen within that period. Right? Are you running for office?
No, I said
Is what?
I don't know if you watch House of Cards.
Oh, yeah. I know of it. I don't watch TV. I don't have time. No, but I know of the show. I think I've seen an episode or two. You watch the entire thing? Binging, right?
I'm trying to study.
Spring break, right? Other questions? And speaking of spring break, have a great break. I'll see you all when you get back. Nice segue.